on personal ground. Also, you have submitted that as mentioned memo.
Submitted.
To that effect has also been circulated yesterday. Miss A. Begum, non-additional public prosecutor, who is in attendance, who is present, has no objection to the above prayer. So, the prayer made on behalf of the learned Amicus Curie is allowed. List the appeal after 1 week on a date to be fixed by the office.
May I beg your lordship? I beg to mention one criminal appeal for listing lordship. In
Or
orders
what
column.
stage?
In orders column lordship.
Orders column,
On Monday lordship.
not Monday. Right, I don't know. List already out to Monday.
For admission, number 1.
This matter comes up for admission for the first time. Life sentence has been meted out, Millards. It's a matter of life sentence, Millards, 302 case. The appellant before your lordships is a patient of chronic schizophrenia, Millards, which was never tried by the trial court.
Nothing medical.
Because
During
there
the
are
trial,
findings that he's a patient of chronic schizophrenia. Yet he was convicted, Millards. 328, 329 was given a complete go by, Millards, in the CRPC. I will follow.
এই নতুন খনসাও নতুন CRPC এখন কি
In the new CRPC, in the new BNSS, Millards, that's 368, 369. 368 and 369.
The present criminal appeal under section 415 within bracket 2 of the Bharatiya Nagorik Surakha Anhita, 2023, corresponding to section 374 within bracket 2, Criminal Procedure Code, is directed against the judgment an order dated 5/6/2024 passed by the learned Sessions Judge Dorong at Mongoldoi in Sessions case number 29 within bracket DM of 2020. By the judgment and order dated 5/6/2024, the accused appellant has been convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo imprisonment for life and to pay a fine of rupees 3,000, in default of payment of fine, to undergo further rigorous imprisonment for 3 months. Before that, heard Mr.
A.
Gautam, learned counsel for the accused appellant, and I am Ms. A. Begum, learned additional public prosecutor for the respondent state. The criminal appeal is admitted for hearing. Issue notice returnable in 4 weeks. As MS Begum, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent state. The issuance of formal notice to the said respondents stands dispensed with extra copy of the memo of appeal. Appeal is admitted. The case records of Sessions case number so and so be called for. List the case after 4 weeks.
Number 2.
2 Millards. It's also a case of life in prison for the offense under section 6 POCSO, Millards.
Hard Mr. A. Gautam, learned counsel for the accused appellant, and MS A Begum, learned additional public prosecutor for the respondent. Number 1, State of Assam. This criminal appeal under section 374(2) Code of Criminal Procedure is directed against a judgment and order dated 7/5/2024 passed by the Court of Learned Additional Sessions Judge cum Special Judge within bracket POCSO, Morigaon, within bracket the Special Court for short. In POCSO case number 17 of 2018, arising out of Zagirot Police Station case number 100/2018. By the judgment and order dated 7/5/2024, the Learned Special Court has convicted the accused appellant for the offense under section 6, Protection of Children from Sexual Offences Act, 2012, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 20,000, in default of payment of fine, to undergo further rigorous imprisonment for 3 months. Full stop. The criminal appeal is admitted for hearing. The case records of POCSO case number 17 of 2018 be called for issue notice returnable in 4 weeks as MS Begum, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice to the said respondent stands dispensed with extra copy as the offense involved is section 6 POCSO Act notification. Deepak Nair, it is ordered accordingly, the learned counsel for the accused appellant shall furnish a copy of the memo to the office of the public prosecutor within 3 days from today, 3 working days from today, for effecting service of notice upon the respondent number 2, informant or victim? Informant. To the officer in charge of the officer in charge, Zagirot Police Station. First off, the learned additional public prosecutor is to obtain a report as the service of notice upon the respondent number 2 on or before, or from the officer in charge, Zagirot Police Station, on or before the returnable date.
Number 3.
POCSO matter request. Yes.
Yes.
Hmm. Okay. Office note dated 14/3/2024 reflects that notice to the respondent number 2 by registered post duty AD has been issued on 14/3/2024. Post of office note dated 24/7/2024 reflects that neither ID card nor unserved notice on the respondent number 2 has been received back from the respondent number 2. Post of in view of the above, let the case be placed before the Lower Jima Court in order to ascertain the service status of the notice supra mentioned above for report. List the case after 2 weeks for report of the Lower Jima Court. 302 delivery is Informant or repeated করার কথা নাই। Yes. No instruction.
Instruction lordship, that's, we have produced.
Yes, Mr. Ahmed.
My lord, family members of the appellant are not interested, my lord.
Okay.
Even my lord,
Hare
One of
Ali,
this one.
Ahed Ali. Heard Mr. A. M. Ahmed, learned counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Full stop. On 21/6/2024. Comma, Mr. Ahmed, learned counsel, had submitted that during the pendency of the appeal, comma, the appellant, comma, Ahed Ali, had expired while undergoing the sentence expired in jail while undergoing sentence. Full stop. Para. It is stated that the appellant, comma, Ahed Ali. No, it is stated that the instant appeal under section 374(2) Code of Criminal Procedure 1973 has been preferred by the appellant, comma, Ahed Ali, to assail a judgment and order dated 16/2/2024, passed by the learned additional session judge, a 5/4/2024 order to the additional sessions judge come special judge within bracket POXO, comma, Morigaon, within brackets the special court for short. In POXO case number 172/2023, comma, arising out of Jagirot Police Station case number 135/2023. Post up by the said judgment and order, comma, the accused appellant had been held guilty for the offense under section 4 within bracket 2 of the Protection of Children, from Sexual Offences Act, comma, 2000. Yes, madam. Service report. By service report.
Lordship, we are trying to contact, but we are not able to contact them in this case, Lordship. Today morning also, I have asked, the office to contact Lordship.
You're B. Sharma.
Yes, sir, my lordship.
Yes, sir. Let us wait then one more week.
Lordship,
Otherwise, we will close this.
Lordship.
Heard Mr. S. Sharma, learned counsel for the applicant appellant, and MS A. Begum, learned additional public prosecutor for the opposite party number 1, comma, state of Assam. MS Begum, learned additional public prosecutor, has sought for and is granted 1 week time to obtain a report as regards service of notice upon the opposite party number 2 from the officer in charge, comma, Bokota Nemuguri Police Station, comma, District Sibahal. Please, that is accordingly after a week on a date to be fixed by the office.
Lordship, regarding this also same prayer, Lordship, from last 3 days, I am trying to contact Lordship.
Okay. Yes,
Paying for bail, my lord,
bail,
Yeah.
you are POXO,
FOXO, my lord,
and wait,
my lord,
wait.
They change,
Have before us,
they change,
have before us 67 days.
oh, my calculation was 676. I'm sorry, ma'am.
Yes, MS Begum.
Accept it. Lordship.
Hmm?
Lordship, they grant. Lordship.
Heard DK Votasaiji, learned counsel for the applicant appellant, NMS A Begum, learned additional public prosecutor for the opposite party number 1, Mintu State of Assam. Poster. The instant application. Under Section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of 67 days. Which is stated to have occurred in preferring the connected accompanying appeal under Section 415 within bracket 2 of the Bharatiya Nagorik Suraksha Sanhita, 2023 within bracket corresponding to section 374(2), Code of Criminal Procedure 1973, bracket close. Post of the accompanying criminal appeal is preferred to a sale. A judgment, an order dated 8/2/2024, passed by the Court of Learned Additional Sessions Judge, come Special Judge within bracket POXO, Morigaon, in POXO case number 13 of 2023. Post of Special Court করে bracket of Special Court bracket of by the judgment and order dated so and so, the applicant appellant has been convicted under section
My lord, 6 and 10.
6 and Protection of Children from Sexual Offences Act, accompanying appeal to assail a judgment and order dated 1/4/2017, passed by the Court of Learned Additional Sessions Judge, Bojali Panchala, in Sessions case number 189 of 2016, whereby the accused or the applicant has been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 10,000 with default stipulation after finding him guilty for the offense under section 302, IPC, read which section 34, IPC. Issue notice returnable in 3 weeks. It is observed that in the event, no, any objection?
Lordship.
The objection, if any, is to be filed invariably on or before the returnable date.
May I request for a short date, minutes, in August,
No.
let's fix date.
Decline.
Great.
For hearing, item number 13.
और किशोर कुमार को hearing ওইটা তো বলে একটু এটা খেলতে পারলাম yes madam টিভি টিভি কি মানে টিভি কি মানে
This appeal is under, has been preferred for conviction under section 302.
ফাইল আছে তাহলে ফোনের ফাইল আছে yes
302 IPC, Lordship. FIR is at page 1. If I may take your Lordship, sir. Viswanath PS
yes
here.
merit appeal has merit or no merit huh
Not much.
not much
She has a case in her favor.
3 years again okay
General diary.
some
reference-
cases are open and shut
But your lordship, the consumption of alcohol, it was found on the stomach of the deceased.
okay let us see yes
General diary reference entry, time is 5:45 PM, 22/6,
Uh-huh.
2018.
Which page you are reading?
Page 1, FIR.
Page 1.
Date of occurrence, Friday, 22/6/2018 at 4:30 PM. Lordship
Date
will,
of occurrence. Who says so?
informant
Huh?
Usha Gore. Here are
Around
the-
4:30, okay, 4:30. General diary entry immediately after 1 hour. Any idea? 611? Is it exhibited? ZD entry 611? Any idea? Not. Has anybody said so?
GD entry number is given,
No, number is given, it is to be exhibited.
not exhibited.
Law requires,
IO has said.
IO has said.
said. Does not mean exhibited. PW
PW 5.
5,
Statement is at
Page?
page 16.
Page 16.
16. Okay. And then the Kailash Sharma,
Kailash Sharma is PW
second
1.
officer. Huh? He is
He is PW 1.
Kailash Sharma.
Yes.
PDB secretary informed over phone that son insulted his elder brother. Who did? They ordered me to go there.
Okay.
Okay. So this GD entry preceded the FIR.
Yes.
Yes, yes,
22/6/18.
yes. Right, tree site.
And there was no
Brother
inquest
killing
report.
brother is 50 site. Brother killing brother. Fratricide. And brother lodging the FIR. Against his own brother. Page 4.
Yes,
Informant is the brother
yes.
of the accused. Informant is also the brother of the deceased.
You see.
Okay. Read the FIR.
Lordship will just note that in the FIR itself, it is mentioned that direction and distance from PS is about 8 kilometers north. And
8 kilometer north.
address is Bamuni Pothar, Roroy Basti.
Okay.
However, Lordship, there was around 7 hours delay in reporting the incident.
Okay,
Page 4, Lordship, is the fire to the officer in charge, 23/6/18.
above mentioned,
With due respect, I would like to inform you that around 4:30 PM on 22/6/18, the above mentioned accused brutally assaulted my brother Mohsen Gaur with his hands and legs in the courtyard of our house and caused serious injury to him. And after some time, my brother Mohsen Gaur
Ready?
passed away.
no, huh? 1 minute, informant is
PwC.
Kumar or and diseased Mohsen. Case of direct evidence or circumstantial? Padmeshwari Gaur. Who is Padmeshwari Gaur?
Wife of the accused.
Wife of accused. PW?
7. Yes, said Lordship, at the time of incident, I was not at home. But when I reached home, I came to know that about that from Srimati Padmeshwari Gaur, the wife of the accused. Therefore, I request you to take action in this regard and oblige. Page 6, death by assault.
Hmm?
At page 6, the charge, death by assault. As follows, that you on the night of 22/6/18 at about 4:30 PM with intention or knowledge of causing death of the victim, Sri Mohsen Gaur assaulted him in Bamuni Pathar village under Biswanath Sariali PS, causing his death, and you thereby have committed the offense of murder punishable under section 302 IPC and within my cognizance.
Now, informant testimony. Okay, page. Nineteen. Number two, that's it. Number two, 9. Huh? PW6, Nikki. PW6, okay. That's it. Yes, please read.
My name is Kusha Gaur, aged about 60 years. I know present accused Son Kumar Gaur, who is my brother. This is Mohsen Gaur, is also my brother, who has been murdered by accused Son Kumar Gaur. The incident took place about 2.5 years ago. On the date of occurrence, that is on Friday, both the accused and the deceased consumed wine, and thereafter there was a quarrel between them. And accused Son Kumar Gaur assaulted Mohsen Gaur and thereby killed him, and thereafter taken the dead body of Mohsen Gaur and kept the same inside the house where Mohsen lived with her accused Son Kumar Gaur. The incident took place at about 4 p.m. and at that time I was available at my workplace, and one Montu, my native villager, he has not been examined, informed me about the incident, and on getting the information, I returned to home at about 5 p.m. and I saw the accused was tied up and with my brother Mohsen Gaur was lying dead inside the house where both Mohsen and Son Kumar Gaur lived. I found some of our native villagers assembled at the
Yes, yes.
place of occurrence. In
Yes.
the meantime, police arrived at the place of occurrence and brought the dead body and the accused after arresting him. I also accompanied the dead body. Thereafter, dead body of my brother Mohsen Gaur was postmortem at Behali PHC. In respect of the incident, I lodged an Ejahar at Vishwanath Sareli PS. Police recorded my statement. Cross-examination by defense. On the date of the incident, I was working as day laborer in the house of Muslim gentleman at a distance of 3 kilometers from our residence. Mohsen was a bachelor and used to work and also consume liquor.
Then next, cross.
I have not seen
Next,
the incident, page 20. I have not seen the incident of killing Mohsen Gaur by accused Son Kumar Gaur by my own eyes, and I have seen the quarrel between them while I was nor I have seen the quarrel between them. While I was returning to home, our native villager Montu reported me about the incident. Prior to my arrival, police reached at the place of occurrence. Lakhin Gaur and Nanda Gaur were available at the place of occurrence. While I reached there, the house where Mohsen and Son Kumar Gaur were living consists of 2 rooms situated east-west direction. Mohsen used to live in the western side of the room. The room where Mohsen was living contained clothes, aina, etc. and the room is kitchen. Dead body of Mohsen was lying on the ground inside the room, looking towards the sky, wearing a short pant and a half shirt. I have seen injury mark on the belly of the deceased, but I have not put off the shirt of the deceased. It is not a fact that Montu did not inform me about the incident. It is not a fact that I have deposed falsely that accused Son Kumar Gaur assaulted Mohsen and killed said Mohsen. Lordship will note that this Montu has not been examined.
Then the
Lakhin
wife
Gaur-
of the accused,
She is Padmeshwari Gaur.
7.
PW 5.
7.
PW 7.
Yes.
At page 21. I know informant Kusha Gaur, who is the elder brother of my husband, Son Kumar Gaur. Accused Son Kumar Gaur is my husband. The date of the occurrence, accused Son Kumar Gaur and his elder brother Mohsen, after consuming liquor, quarreled with each other. Thereafter, they were fighting and accused Son Kumar Gaur assaulted Mohsen Gaur and thereby killed Mohsen Gaur. At the time of the incident, I was available at my workplace. One of our native villagers, Mohadev, over phone informed about the incident to the police, and after arrival of the police, arrested the accused and brought the dead body along with the accused. Police recorded my statement.
Okay,
He
let
has
us see.
witnessed the incident and Mohadev has not been examined. On the date of the incident, I alone went to my workplace. After returning to home, I found many people assembled at our village residence. I found my husband was in a drunken condition and nearby people tied him up at the place of occurrence. I have not seen the incident of murder with my own eyes.
Doctor,
PW 3, Dr. Deepak Kumar Biswas.
FIR was lost 23 on the same day, okay.
Doctor's statement is at page 12.
Uh,
PW 3. Senior Medical and Health Officer, Behali Block PHC. On 23/6/2018, I was working in Behali Block PHC as Senior Medical and Health Officer. On that day, I examined the dead body of Mohsen Gaur, male, 40 years, by reference of BNC PS GD entry number 611/18 dated 22/6/18 and identified by Constable 367 Ratna Mahanta. The findings were as follows. There were froth over mouth and dislocation of intervertebral joint in both between cervical and cervical 2 vertebra. There was fracture right second, fourth rib at anterior axillary line.
এই সৰু
Pleura
এইখন
and
সৰু
right
medical
lung found punctured with hemorrhage. Heart found empty. Liver and spleen found ruptured. Stomach contained liquid content, smell like alcohol. All the injuries were of antemortem in nature. The time since death was within 24 hours. The death was due to cerebrovascular accident following severe hypervolumic shock as a result of injuries sustained. I cannot say who performed the inquest over the dead body. If the deceased had fallen with a very heavy force on the hard substance, the ribs might break in that way. The liver and spleen were ruptured due to fracture of the ribs. I found rigor mortis in the dead body and therefore I found the death to have occurred within 24 hours. The rigor mortis depends upon incident. In winter, rigor mortis develops lately in comparison with summer season.
Cerebrovascular accident is stroke.
Maybe due to fall also.
Hypovolemic. What is hypovolemic? Hypovolemic. Trial portal simple terms of lead hypovolemic. Hypo. Hypovolemic. Hypovolemic.
Emergency condition in which severe blood or other fluid loss makes the heart unable to pump enough.
STUP. Polyemia. Shock basically. Decreasing the volume of circulating blood. Basically shock leading to following severe hypovolemic shock. So shock leading to stroke. That is the reason. As a result of the injuries sustained. Okay. We perform request if the disease has fallen with very heavy force on a hard substance, the ribs might break in that way. The liver and spleen were ruptured due to fracture of the ribs. And I found rigor mortis. Yes,
PW4 Lordship is Mahadev Gaur.
let us then other 1, 2.
Yes, Lordship.
Koilas, that was the
Kailash
who
Sharma.
informed the police station in that first point of time. Okay. Co-villager.
The hearsay witness. I know accused Son Kumar Gaur. He is my co-villager. Informant Kusha Gaur is the elder brother of the accused. I'm reading page 8. The incident took place in the month of May, June last year. While I was in my shop, someone informed me over phone that an incident of murder had taken place in the house of the accused. We went there and saw the dead body of Mohsen Gaur, the elder brother of the accused, lying inside his house, their house. I saw that the hands of the accused were kept tied up inside the room by the people present there. The neighbors said that the accused had killed his elder brother. I informed the police. Police went there, took away the accused and the dead body. Police examined B. I did not see any injury on the dead body. I found Mahadev Gaur, Seniram Pro, the village headman at the place of occurrence. Mahadev Gaur informed me over phone that about the incident. The place of occurrence is 5 kilometers from my shop. Virchandra Ray is the VDP Nayak. He and I together came to the place of occurrence. It is not a fact that I have deposed falsely that the neighbors said that the accused had committed the murder. I did not see any injury on the person of the accused. The neighbors and Seniram Crow, as well as the village headman, has not been examined.
Mahadev was examined.
He is PW4. Seniram Crow, village headman, the neighbors, they were not. PW2 is the VDP Nayak, Bir Chandra Rai. I'm reading page 10. Accused Son Kumar Gaur is our co-villager. I know Kusha Gaur about 2 years ago. Mahadev Gaur called us over phone and asked us to go near their house. I am the Nayak of VDP. The place of occurrence is the house of the accused. Going there, we found the accused being kept tight. I heard that the accused had killed his elder brother. I saw that the dead body of the accused elder brother was lying inside the house. Police kept the accused tied up. We gave the information at the police station. Police took away the accused. Police also examined us. The dead body was kept covered with a cloth. I did not see any injury. In cross, I did not see the incident. It is not a fact that the neighbors of the accused did not tell me that the accused had killed his elder brother. I did not see as to who had kept the accused tied up.
Yes, nobody is saying who had kept the
Accused tied up.
accused tied up.
PW3 statement was read, Lordship, is the doctor. PW4 is Mahadev Gaur, page 14. He's a cultivator by profession. On note, accused Son Kumar Gaur is our co-villager. The informant is the elder brother of the accused. About 11 a.m. on 22/6/18, while I was returning from the market, I saw people in front of the house of the accused. I came, though the village of the accused, I saw gathering of people inside a temple of the accused person's village. Going there, I saw that Mohsen Gaur was lying dead. The dead body was lying beside the road. The accused person was in a heavily drunk state and creating nuisance. The accused person's wife said that the accused had killed Mohsen Gaur. I informed the VDP Nayak and the secretary Kailash Sharma and Kamaleswar Hajarika, respectively, over phone. They came and called the police. I saw the legs of the dead body swollen. The wife of the accused said that the accused assaulted the deceased on his private part. Police came and sent the dead body for post-mortem examination. Police apprehended the accused. Police examined me. It is not a fact that in my statement before police, I did not state that around 12 noon on the day of the incident, while I was returning from the market, I heard people raising commotion on the road near a temple situated near the house of the accused person, that the dead body of the accused was lying beside the road, and that the accused person's wife had killed the accused person's brother Mohsen. It is a fact that the accused had killed Mohsen. It is not a fact that I did not state before the police that returning from the market, I stopped at the place of occurrence. The accused was not in his senses, under the influence of alcohol, and was found naked. My brother helped him to put on his clothes. Your Lordship will note that Kamaleswar Hazarika was not examined. In his 313, accused has said that at page 24, it is true that Mohsen Gaur has died, but I have not murdered him. In fact, Mohsen Gaur consumed country liquor, but did not have food continuously for 3 to 4 days, and as such, Mohsen Gaur died. Postmortem report, information furnished by police as per inquest report. Page 47. Yes, when your lordship reads with page 17, in the cross PW5, the IO has said that the copy of the inquest report is not available in the case diary. It is not a fact that I did not get the inquest done by the magistrate. Later says, I have found the inquest report in the case diary. A copy is there. I'm reading page 17, Lordship. The deceased, his elder brother and sister-in-law lived in the house. Padmeswari Gaur is his sister-in-law. Witness Mahadev Gaur did not state before me that returning from the market, he stopped at the place of occurrence. I did not seize any weapon as the assault on the deceased was made with hands. The accused was kept tied up with a gamusa towel. I did not seize the gamusa. It is not a fact that I have submitted the charge sheet against him without investigating the case properly.
মহাদেবলি কইলে মহাদেবলি কইলে হ্যাঁ মহাদেবলি কইয়ার লগে লগে মহাদেব মহাদেবের PW4 মহাদেবে আহোতে কিন্তু টাইম নাছিল he was not in senses under influence and was found naked and he was heavily drunk instead and creating nuisance. When and how he was tied?
Lordship, nothing on record.
Uh,
Nothing on record.
hey, here is some. Is there some? Statement. That's a statement. Is there? You have to. The position is there. Ah.
One statement, may I refer?
হাতের আর ভরিরে হ্যান্ডগ্লোভ and
Page 15, no? Page 15.
Page 15, cross-examination of PW4. First paragraph, last two lines, that the dead body of the accused is lying beside the road and that the accused person's wife had killed the accused person's brother. Hussain.
last page 15
Page 15, 1-5.
1-5
Cross-examination of PW4. First paragraph, last two lines.
I heard people raising commotion on the road near the temple situated near the house of the accused person, that the dead body of the accused was lying beside the road and that the accused person's wife had killed the accused person's brother Mohsen.
Because as per evidence of PW4 also, accused person's wife said that the accused had killed Mohsen Gaur.
during the stage of investigation one witness was eyewitness but before the court that witness became a hearsay witness.
Maybe
During the investigation, it was that witness was an eyewitness
eyewitness.
as per 161.
Yes, my lord.
But
PW seven, my lord.
when that witness gave testimony before the court, she became
Here's
hearsay witness.
PW seven, my lord. Padmeswari, wife of the accused. Because she,
She depicted vividly what happened on that day. Nothing, no arms,
arms,
no arms or stick or something like
my
that.
lord.
Simple hands-on combat between the two
Oh,
brothers.
Maybe she, PW four may be the,
Huh?
she may be the perpetrator. I may be wrong.
No.
Lordship, because vividly she has explained. The wife of the accused said that to PW four, accused assaulted the deceased on the private part. Police came and sent the dead body to PM.
Accused, assaulted, kicks and blows. Because as per the story, the disease was raising halla after consuming liquor on the road. Then the accused, who was his brother, he brought him back to his house. Then there was quarrel. And because the accused was more in senses, both were consuming alcohol, but the accused was more in senses and I think physically more stronger, perhaps. Gave blows and kicks. Thereafter, put him inside a room. You stay here. Intention was not there.
My lord.
Intention was not there.
Yes.
But that to restrain him,
My lord.
he was kept inside a room. That is a story of the wife.
And liquor, it was
Then after 2 hours, when she went there inside the room, found that no pulses, already gone.
Lordship.
And maybe the story may be that 2-3 days he did not have any food.
As has been explained by the accused person.
And then it will be otherwise. Secondly,
My lord. My lord.
if had the intention
My lord.
and knows that this disease did not had food for 2-3 days, very weak, giving kicks on ribs and other things
Severe injuries were found.
may lead to death.
Lordship.
Section 303, secondly.
Second.
But
But injuries were found in the body.
those are not in the form of substantive evidence. That is, then it will be case of substantial evidence, circumstantial.
Circumstantial evidence.
And circumstantial evidence, only things which are emerging is that the disease, the accused and his wife used to reside in one
Together.
house. Nobody said about leaving them, seeing them together
During the relevant point of time.
on that day
Lost.
even. Then the disease was found dead inside his house,
On a courtyard.
in the courtyard. And nobody has explained, because PW4, he saw the accused in a drunken state creating these nuisances, right? Cross, he said, accused was not in senses under influence of alcohol and was found naked, right? He did not say about how the accused was tied inside the room. Only PW4 saw him free, accused. But all the accused, other witnesses,
Yes.
By the time they saw the accused, he was tied. This was also how the accused was tied by persons. Nobody deposed it. Or who tied him. That is one missing.
No.
One missing. And if we see the doctor's evidence, he has not said it homicide directly. See, read it once again.
That was due to cerebrovascular.
There are, because that is why we have seen what he has said. And nobody had seen any injury on the external side. Witnesses were clear. Then MO, medical officer, said the death was due to cerebrovascular accident, which I said stroke. Following
Injury sustained.
severe hypovolemic shock. Shock leading to stroke.
No, as a result of the injury sustained.
As a result of injury sustained. Now cross. What are the injuries?
Lordship.
Fracture of second and third rib of anterior auxiliary line, pleura and right lung. Found punctured with hemorrhage. Right?
Right.
Now come to cross. If the disease had fallen with very heavy force on a hard substance, the ribs might break in that way. In that way. Second and third. The liver and spleen,
Page 13, my lord.
13, ruptured due to fracture of the ribs.
Yes. Rupture due to fracture of the ribs.
Liver and spleen found ruptured. And this second and fourth rib at so-and-so pleura, right lung found punctured with hemorrhage. So he is not saying that it is injury sustained. Injury can be sustained due to
Fall also.
fall also.
But
Possibility.
rupture of spleen takes place due to
Ah.
fall.
So possibility are about two.
Lordship.
Chain will be, but that all circumstances must be proved.
But at the same time, the evidence of the doctor or the opinion of the doctor should not be the last word of the prosecution.
Huh?
But other links I don't find complete, my lord.
That is a difficulty. Legal,
Lordship.
for legal conviction. We'll come back.
Page 27, 30. Judgment.
Whether it is a case where the accused really owes an explanation.
How come she is present has to be proved? On the,
Preceding, attending, succeeding. So
Okay.
succeeding the event of date,
but he
his
was,
presence in the house was there.
no, but he was
Succeeding-
tied, he was tied in a nearby temple, no? Nearby
Huh?
temple. He was tied in a nearby temple.
Where from you're saying?
I found it.
Nearby temple?
Oh, first, as per PW1, I
Huh?
saw the hands of the accused were kept tied.
Which one? Which one?
PW1,
Page,
I saw that the hands of the accused, last line, tied up inside the room by the people present there.
Oh,
Say that the accused can,
PW2 also.
PW2 also.
I
I
saw the
found an
dead body of the
empty house.
accused person's elder brother lying inside the house.
Yes.
People kept the accused tied up.
Yeah.
Though directly inside the room, but inside the house, but
Right.
it appears to be so. Then PW4,
Lordship, PW4,
he saw the
I saw
accused
gathering
gathering.
of people inside a temple of accused person's village.
Which PW4?
4,
page 14,
Which page?
14.
14, 1, 4. Oh, he saw gathering. I saw gathering of people inside a temple of accused person's village. Going there,
First part, while I was returning from the market, I saw people in front of the house of the accused.
Hello.
And this Mahadev perhaps, Mahadev is not a resident of same village. That is why he said, I came to the village of the accused. He is a resident of Rare Bosti, Bamuni Pathar.
Bamuni Pathar.
And as per the charge, Bamuni Pathar village, Rare Bosti, Bamuni Pathar. Maybe one part of the village.
Hello. Going there, I saw that Moshe and God was lying dead there.
Original. Translated to so. All are translated. Horrible handwriting. Horrible handwriting. Handwriting are difficult to read. Nobody has deposed that they saw, any of them saw the accused at the first point of time. Everybody is saying that when he reached the PO, there was gathering of people.
And who apprehended?
Who apprehended? That is also not there.
As per the IOPW5, the place of occurrence is the house of the
House.
accused. I found a
Hey,
dead body lying on the floor. I
Kumar-
found the
Kumar
accused
is-
being kept apprehended.
Wow. No. This was, yes, he had all a reported witness, but who reported them? Nobody knows. Mahadev reported PW1 and PW2,
I know.
right? Thereafter, they arrived at a place of occurrence. Thereafter, they reported to the police. Then police came there,
Lordship.
right? And then the wife, who appeared to be the eyewitness as per the FIR, when she gave testimony, she said that she was
Came
not
to-
there.
Yes,
She was also, again, she was reported by Mahadev,
Mahadev,
and that lady was not confronted with her previous statement,
previous day. Lordship.
right? Huh? Mahadev said, accused wife said that the accused had killed Moshen God,
My lord.
right? So as per the FIR and as per the testimony of PW4, Mahadev, the lady appeared to be the eyewitness.
Oh, as per Mahadev, my lord, cross-examination,
Yes.
that I was submitting, my lord, that accused person's wife had killed brother.
Page 15.
Huh?
I heard people
As
praising.
per Mahadev, there is
Mahadev,
some mistake, but it's also translated.
Suggestion
My
was
lord.
given.
suggestion.
It's a translated
stated.
one, lordship, may I see the original?
I saw the legs of the dead body swollen. The wife of the accused said that the accused assaulted the disease in his private
Private
parts,
part.
right? Then third line, paragraph 15. The accused person's wife said that the accused had killed Moshen Gaur, right? Now, from the testimony of PW4, Mahadev, the wife, PW7, appeared to be eyewitness, right?
Then cross-examination,
What's again what? First part is suggestion. Second part is suggestion. Only one part. The accused was not in his senses under the influence of alcohol and was found naked. My brother helped him to put on his clothes. We don't know who is his brother. Mahadev. That he was confronted with his previous statement, but nothing was marked and put to the IO. So it remained in the realm of suggestion only.
no, I was submitting the paragraph prior to the second paragraph of cross-examination, last
Mhm.
line.
Hmm.
Part of that suggestion which is put.
Part of the all the suggestions.
Maybe I have not seen the original, yes, it seems, my lord,
Try to read and decipher from the
my
original.
lord.
Make an effort. Because I will not be able to. Quality of handwriting. Mondir was there. I saw it.
Cross-examination of PW4, my lord. সত্য নহয় যে মই দুদিনৰ very difficult. ঘটনাৰ দিনৰ 12 মান বজাত মই বজাৰৰ পৰা ঘূৰি অহাৰ সময়ত আছামী ঘৰৰ ভিতৰত মন্দিৰ এটাৰ ওচৰৰ ৰাস্তাত মানুহৰ হাল্লা আছামীৰ মৃতদেহ ৰাস্তাৰ কাষত পৰি থকা দেখা পাওঁ বা আছামীৰ পত্নীয়ে আছামীক জনক হত্যা কৰে আছামীৰ জনক হত্যা কৰে আছামীৰ ভায়েকজনক হত্যা কৰে ভায়েকজনক হত্যা কৰে আছামীৰ ভায়েক or something like that. Probably the prosecution could not prove beyond reasonable doubt who is the perpetrator, my lord. Because his presence could have been proved, my lord, it is not there. No
With some more efforts. Because I have seen the search it. The listed witnesses were examined. Nobody was left out. Right. Page 56.
Yes, no. Padmeswari, Kailash Sharma, Bir Chandra Roy, or Mahadev Gaur.
So, IO expected that the case would be proved with the aid of these witnesses.
My lord,
And when nobody had seen him,
my lord.
actually everything happened because law is also that conviction can be based on the basis of a testimony of a solitary witness if it is that testimony is found to be credible.
Law, sure.
Now, here, this listed witness number 1 had deviated from our original 161
No,
statement.
PW7, wife of the, yes. She was.
And there is nothing to lend support to her witness. That she was there. Nobody deposed.
Because Lordship, as per evidence of PW4, she vividly explained as to the nature of injuries. Maybe she's the eyewitness or she may be the perpetrator.
Perpetrator maybe no silent, aided,
Okay.
abetted maybe.
My lord.
Not basically the intention was not there otherwise.
With fist and blow was.
Kicks and blows,
Yes.
no external injury. Nobody, no witness said
Was
that.
Is it about victim or is it about 60?
No weapon.
50. Oh, no weapon.
No weapon. And everybody said, PW1 and 2 at least said, that they did not notice any external. I did not see any injury. PW2 said, PW1 said, I did not see any injury on the dead body.
Right.
So everything was internal.
Turn up.
That was
Because of the
hemorrhage,
fist and blow. and they
ribs, fracture of ribs,
Ribs.
rupture of
were
spleen,
spleen,
leading to shock, leading to stroke.
Stroke.
And
conjunction
possibility is
effect
there,
is there.
possibility is there,
Yes.
and postmortem says presence of alcohol.
Still. So maybe they were consuming and thereafter they engaged with fight.
What we do today, we will have no time to complete. We'll do the basic framework. Put it on. Oh, Monday ki ase bro? Next one again. Monday ki ase, huh? Kiman ase? Monday kiman ase? Itu ki? Itu Monday. Orders, admission. Tuesday di yun. Later it will keep back. Monday we do it. Monday. Monday good. Okay. Whatever is possible today, we'll do it. And Monday.
Another acquittal.
We'll see. Maybe. Agreed by and dissatisfied with the with adjustment and order dated 26/04/2021. Please take your seat. Passed by the Court of Learned Additional Sessions Judge FTC Bishwanath Sariali in Sessions Case number 111 of 2018. The accused appellant has preferred the instant criminal appeal under section 383 CI Code of so and so from jail. Full stop. By the judgment and order dated 26/04/2021, the Court of Learned Additional Session Judge FTC Bishwanath Saili has convicted no, এনেকে লিখো। The accused in the trial faced a charge of fratricide, FRATRICIDE. And after the trial, the court of learned so and so has convicted the accused appellant for committing murder of his brother post of finding the accused appellant guilty of the offense under section 300, Indian Penal Code, the accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for 6 months under section 302, IPC. Full stop. It has been ordered that a period of detention already undergone by the accused during investigation, inquiry and trial or trial shall be set off from the sentence of imprisonment. Full stop. Para. MSB Chaudhary, learned amicus curiae, appearing for the appearing for the applicant appellant, has submitted that during a trial, the prosecution examined 7 number of witnesses in order to bring home the charge. Full stop. But, none of the seven, including the medical officer and the investigating officer. So, but none of the non-official witnesses, prosecution witnesses, deposed to the effect that they had witnessed any incident of assault on the deceased by the accused, leading to the death of the deceased, who was incidentally, who was a brother, who was his brother, who was one of his brothers. MS Chaudhary has further referred to the medical evidence to submit that the medical evidence was not enough to point unerringly towards homicidal death of the deceased, as the autopsy doctor had opined that the death was due to cerebrovascular accident following severe hypovolemic shock. Page 13 hours. Full stop. As the case was based on circumstantial evidence, comma, the duty was cast upon the prosecution to prove each of the circumstances independently, and thereafter, comma, to complete the chain of circumstances to rule out any possibility and to rule out any possibility of involvement of any other person. Full stop. MS Chaudhary has strenuously contended that the prosecution evidence was not sufficient to draw a conclusion that it was due to any act, any culpability on the part of the accused, culpability of the accused and accused only, he and he only. The date of the disease had resulted. In the absence of any direct evidence, comma, insufficiency in respect of the insufficiency in the medical evidence, and many gaps in the chain of circumstances, comma, the accused is clearly entitled for the benefit of doubt, and as such, comma, the judgment and order of conviction and sentence of the learned trial court needs to be interfered with. First of all, para au contraire, MS B. Bhuiyan, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty, learned counsel for the respondent state, has contended that the one of the vital circumstances is that the deceased and the accused used to reside together in the same house, and the dead body of the deceased was found inside that house, wherein the accused was also present, at the relevant point of time, full stop, the prosecution witnesses, comma, in their testimonies, comma, had mentioned about the presence of the accused. Full stop. It is further contended that in such fact situation, comma, the accused owed an explanation regarding the circumstances which led to the death of his elder brother, younger brother, his brother. Full stop. MS Bhuya has further submitted that the other brother of the accused and the deceased, comma, that is the informant, that's PW1, and the wife of the accused, comma, PW7, had both implicated the accused for the death of the deceased. Full stop. And full stop. It is submitted by Ms. Bhuya that the Lorette trial court, after thorough evaluation of the entire evidence stroke materials on record, comma, had returned the finding of guilt recording regions, and as such, comma, the present appeal is not merited. Full stop. Para. We have given due consideration to the submissions of the learned counsel for the parties. Full stop. The submissions of the parties are considered, are duly considered. With the vis-a-vis the evidence stroke materials on record, including the testimonies of the prosecution witnesses and the documentary evidence led during the course of the trial. Full stop. Para. Before a discussion on the before going before appreciation of the evidence stroke materials on record, comma, it appears necessary to delineate the sequence of events leading to the registration of the case, comma, leading to the submission of the search sheet against the accused appellant after registration of the the alleged crime as Bishwanath Sarili, Police Station case number 151/2018. Full stop. Para. It was one of the brothers of the deceased and the accused, comma, namely, comma, Kukhogor, PW 1, 6, PW 6. Who lodged the first information report before the officer in charge, Bishwanath Sarili Police Station on 26/3/2018. Alleging inter alia that at around 4:30 p.m. on 22/06/2018, his brother, Mochen, would do correct, M-O-S-H, M-O-C-H. M-O-C-H-E-N, Mochen, Gaur, G-O-R-H. Brutally assaulted Son Kumar Gaur, S-O-N, Son Kumar Gaur, case brought silent. Brutally assaulted his another brother, Mochen Gaur, by giving blows by giving fist blows and kicks with legs in the courtyard of their house. As a result of which, Mochen Gaur breathed his last after some time. Full stop. The informant in the affair mentioned that while the time of the incident he was not at home, and he came to know about the incident from the wife of the accused, Padmeshwari Gaur, within bracket PW 7. It has emerged that the affair was written by a scribe, and as per his endorsement, scribe, Bharat Datta, and as per his endorsement in the affair, the same was written as per the version of the informant and was read over to him, and the contents was read over to him. Dosto, para. On receipt of the Hajar Command Officer in charge, Bishwanath Sarili Police Station registered the same as Bishwanath Sarili Police Station case number 151 of 2018 for the offence under section 302, IPC on 23/06/2018. Full stop. And entrusted one Pradeep Hazarika, a sub-inspector of police attached to Bishwanath Sarili Police Station as investigating officer of the case. Full stop. Para. During the course of investigation, the IO of the case, Pradeep Hazarika, PW5, visited the place of occurrence and prepared a PO, place of occurrence, that is the house of the deceased and the accused, and prepared a sketch map of the PO within bracket EXT 2. The statements of the witnesses were recorded under section 161 CRPC. After conducting inquest on the dead body of the deceased, the dead body was forwarded to Behali block. Behali block Primary Health Center, PHC, for postmortem examination. The postmortem examination on the dead body of the deceased was performed in Behali block PHC on 23/06/2018, and the autopsy doctor submitted recorded his findings in the postmortem examination PME report EXT1 post-op. ইয়াতে এটা লিখি দিব, মাজত সোমাব লাগিব। The IO appropriate জায়গাত সোমাই দিব। The IO after reaching the place of occurrence took the accused into custody. After completing investigation into the case, Bishwanath Sarili so and so, the IO laid a charge sheet under section 173 to CRPC. Right, charge sheet number 55. 111/2018 on 30/8/2018, finding a primacy case under section 302 IPC well established against the accused. Full stop. Para. After submission of the charge sheet, the Court of Learned Subdivisional Judicial Magistrate M. Vishwanath Saheli secured the appearance of the accused from jail custody on 25/10/2018. Full stop. And furnished the copies to him in compliance of the procedure set forth in section 207 CRPC. Full stop. As the offense under section 302 IPC is found exclusively triable by the Court of Sessions, the learned subdivisional judicial magistrate committed the case records of GR case number 293/2018. We did work corresponding. Case records of GR case number 293/2018 to the Court of Learned Additional Session Judge Vishwanath Saheli. By an order of commitment dated 25/10/2018 passed under section 209 CRPC. Full stop. The learned additional public the learned public prosecutor was notified accordingly. Full stop. Para. On appearance of the accused or on receipt of the case records of GR case number so pursuant to the order of commitment dated 25/10/2018, the Court of Learned Additional Session Judge FTC Vishwanath Saheli, Sonitpur, within bracket, the trial court person, registered the same as Sessions case number 111 of 2018. Full stop. After appearance of the accused before it and after hearing the learned public prosecutor and the learned defense counsel and upon perusal of the materials on record, the learned trial court, on 1/12/2018, framed the following charge against the accused. Page 6. Para. During the course of the trial, the prosecution examined 7 number of witnesses and exhibited 4 number of documents in order to bring home the charge against the accused. Full stop. After closure of the prosecution witness says, after closure of the prosecution evidence, the accused was examined under section 313 CRPC, and the incriminating circumstances appearing from the evidence of the prosecution witnesses were put to him. Full stop. The To the most of the queries comma the accused stated that the accused admitted them to be true. Forwarding an explanation from his end, from his side, uh, comma, by giving an explanation from his side at the end of such examination. Full stop. The accused had, however, declined to adduce any evidence in his defense. Full stop. After hearing the learned counsel for the parties and after appreciation of the evidence on record, evidence to materials on record, comma, the learned trial court proceeded to render the judgment and order, impugn judgment and order, finding the accused guilty of the offense of murder so after hearing the accused on the point of sentence. Point of sentence. Under section 235(2) CRPC, the accused has been sentenced in a manner indicated above. Monday. Had B. Chaudhary. Again, লিখে দিব। List the parted podium. Parted podium. List the case on Monday. Monday when date to দিব as parted.
Where is Silva?
On last occasion, they asked me to make research on section 52A.
Yes.
With regard to collection of samples. I have gone through. And this provision was inserted in 1989.
89.
The objection
And a notification, connected notification was of
56. 56. I have checked up the different judgments, but in not a single judgment, there was the notification was dealt with, except Mohanlal. In Mohanlal case, the notification of and another judgment of 2023, where Supreme Court says that the notification was this is the language also.
which year? Which notification? Huh?
2023, it is not reported in other journal. It is reported 2023.
Notification.
No, it is judgment of Supreme Court.
Ah.
And I am relying on paragraph 7. Here, I am referring this judgment only to place before a lordship. That notification were recognized by the Honorable Supreme Court. Paragraph 7. Page 5.
Hey, more packet to round table of us. Mongila to Mongila.
What is the?
Mongilal.
I have placed that one.
Mangilal versus State of Madhya Pradesh.
You placed?
Yes. Earlier, I placed this.
Come to paragraph
One
paragraph
minute,
7. Lords.
Just a minute.
Not
আর ওটা আছে নাকি? নাই না, আর ওটা আছে। No, SCC, no, sure. Yes, paragraph
Paragraph 7 lakhs.
starts with,
To be noted,
yes,
to be noted, the aforesaid notification was in existence at the time of commission of the offence. Alleged in the case on hand, it stood repealed with effect from 23/12/2022. Latest notification. That notification number GR so and so. In any case, a notification issued in derogation of the power conferred under subsection 1 of 52A can never contradict the main provision, particularly subsection 2. However, any guideline issued by way of notification in consonance with section 52A of the NDPS Act has to be followed mandatorily. My submission is.
oh, to understand this paragraph, you have to read the previous paragraphs.
Correct. Lord. No, that's my point. I am urging the point. Because notification is every time recognized by the Supreme Court. But that should not be in derogation of the section 52A. And
No, where, in which other case the notification was specifically referred
in
to?
Mohanlal.
Mohanlal, yes, Mohanlal. What does Mohanlal say?
Let's say before that, he will also come to the statement of objection to result for 89 amendment. For 89 amendment. That is also important to know.
Where is that available?
Let's see, I have two books. But in High Court's book, probably that 89 reasons is not there.
Can you provide us?
Because the scheme of the act is different from that another access.
Mohanlal earlier question I placed one copy.
Mohanlal is available.
Let's see the statement of object and vision of Act of 2 of 1989. In recent years, India has been facing a problem of transit traffic in illicit drugs. The spillover from such traffic has caused problem of abuse and addiction. The Narcotic Drugs and Psychotic Substance Act 1985 provides deterrent punishment of drugs trafficking offences, even though the major offences are not non-bailable by virtue of the level of punishments. On technical grounds, drug offences were being released on bail. In the light of certain difficulties faced in the enforcement of the Narcotics, Drugs and Psychotic Substance Act 1985, the need to amend the law for to further strengthen it has been held. 2. A cabinet subcommittee which was constituted for combating drug trafficking and preventing drug abuse also made a number of recommendations of strengthening the existing law. In the light of recommendation of the cabinet subcommittee and the working of the Narcotic Drugs and Psychotic Substance in 1985, in the last 3 years, it is proposed to amend the said act. These amendments inter alia provides for the following. 1. To constitute a national fund for control of drugs abuse to meet the expenses incurred in connection with measures for combating illegal traffic and preventing drug abuse. 2. To bring certain controlled substance which are used for manufacture of narcotic drugs and psychotic substance under the ambit of Narcotic Drug and Psychotic Substance Act 1985 and to provide deterrent punishment for violation thereof. 3. To provide that no sentence awarded under the act shall be suspended, remitted or commuted. 4. To provide for pre-trial disposal of seized drugs. 5. To provide death penalty on second conviction in respect of specific offences involving specific quantity of drugs. 6. To provide for forfeiture of property and detailed procedure relating to same. 7. To provide the offences shall be cognizably not committed. So this was the purpose for amending, proposing 89 amendment laws. And in 89, Lordship section 52A was inserted. And Lordship, before that, different notifications were in operation, including one of 89 where it is provided. That is also noted in Mohanlal's case also. Lordship.
Let us read this paragraph 4 of Mongila.
Lordship.
4 is regarding disposal, paragraph 5.
Oh, paragraph.
Paragraph 5.
We start from subsection 2. Subsection 2 of section 52A of the NDPS Act mandates a competent officer to prepare an inventory of such narcotic drugs with adequate particulars. This has to be followed thorough and appropriate application to the magistrate concerned for purpose of certifying the correctness of inventory, taking relevant photographs in his presence and certifying them as true, or taking trial of samples in his presence with certification. Such an application can be filed for any one of the aforesaid three purposes. The object behind this is to have an elementary supervision by the magistrate over the disposal of seized contraband. Such inventories, photographs, and list of samples drawn with certification by magistrate would constitute a primary evidence. Therefore, when there is a non-compliance of section 52A NDPS Act, where certification of magistrate is taking any inventory, photographs, or list of samples would constitute primary evidence.
Do not constitute primary evidence.
Yes, if it is section 52 is not correct.
Then 6.
The obvious reason behind this provision is to inject fair play in process of investigation. Section 52A of the NDPS Act is mandatory rule of evidence, which requires the physical presence of a magistrate followed by an order facilitating his approval either for certifying an inventory or for a photograph taken apart from list of samples drawn. In due compliance of section 52A(1) of the NDPS Act, the Ministry of Finance, Department of Revenue.
That is another part.
Notification 2007.
Then you read paragraph 7.
Yes. To be noted, the aforesaid notification was in existence at the time of commission of the offence, alleged in the case in hand, on hand. It stood repealed with effect from 23/12.
This part is not correct because it stood repeal in 2015 by another notification.
Lordship,
This is wrong. We have already observed with respect because Mohanlal mentioned about it. Then that 2015 notification was repealed by 2022 notification.
in repeal section of this 2023.
Read 2022.
29, section 20, rule 29,
No, 22 rules,
22 rules.
22 notification. See
See,
what it repeals.
Rule 29. I'm reading it. The standing order 1 of 88.
Repeal 29. Standing order 88,
88,
88,
uh,
89.
88. Then issue notification Narcotic Control Bureau 1 of 89.
Gazette of India,
issued by the-
10th May 2007,
What's it?
and notification dated 16 January 2015.
1630 is there.
Yes. Let's say 10th May 2007 is also.
All those were repealed. 2015 repealed some part of it, earlier part.
See, but here published in the official gazette of the organization, dated 16 January 2015.
Second,
I repeat.
2015.
2030.
I have.
So,
The packet
Lordship,
of the-
here, the entire notification, all the previous notification has been repeated.
Hmm.
Whatever stated in rule 29 also. And two is also important also. Notwithstanding such repeats, anything done or any action taken or purported to be taken or done or taken under any of the standing order or notification repealed by rule 1 shall, insofar as is not inconsistent with the provision of these rules, be deemed to have been done or taken under corresponding provision of these rules.
Whatever it may be, please now see paragraph 8,
Proxy, Miller.
Mongila.
Before any proposed disposal, restriction made under section 52A of the NDPS Act requires to be duly complied with, starting with an application to that effect. The court should be satisfied with such compliance while deciding the case. The onus is entirely on the prosecution in a given case to satisfy the court when such an issue arises for consideration.
This part, next part.
Production of seized materials is a factor to establish siege followed by recovery. One has to remember that the provision of NDPS Act are both stringent and rigorous, and therefore the burden heavily lies on the prosecution.
Next.
Non-production of a physical evidence would lead to a negative inference within the meaning of section 114G of the Indian Evidence Act, 1872. The procedure contemplated, though through the notification, has an element of fair play, such as deposit of the seal, numbering the containers in seriatim wise, and keeping them in lots, preceded by compliance of the procedure for drawn samples. The aforesaid stated principle are dealt with in the extent of the Noor state of Punjab. Guideline issued should not only be substantially complied with, but also in case involving penal proceedings vis-a-vis the departmental proceeding rigorous of such guideline may be insisted upon. Another important factor which must be borne in mind is as to whether such direction have been issued in terms of provision of the statute or not. When directions are issued by an authority having the legal sanctions granted, therefore, it becomes obligatory on the part of the subordinate authority.
So it is to comply therewith.
them.
Now, next 91,
Recently,
the corollary.
this court in the state of Kerala versus Korean Abraham followed the earlier decision of this court in of India as a so and so, held the statutory instructions are mandatory in nature.
Next 91.
The logical corollary of the discussion is that the guideline of such as those present in the standing order cannot be valiantly floated and substantially compliance therewith must be insisted upon for so that the sanctity of the physical evidence in such case remains intact. Clearly, there has been no substantial compliance with these guidelines by investigating authority, which leads to drawing up the adverse inference against them to the effect that such evidence been produced, the same would have gone against the prosecution. 92.
Then Mohanlal was there.
Yes, sir.
And then you come to 96.
Last but not the least, physical evidence relating to 3 samples taken from bulk amount of heroin was also not produced. Even if it is accepted for the sake of argument that the bulk quantity was destroyed, the samples were essential to be produced and proved as primary evidence for the purpose of establishing the fact of recovery heroin as envisaged under section 52 of the Act.
Then 100.
Physical evidence of a case of this nature being the property of the court should have treated to be synchronic. Non-production of thereof would warrant drawing a negative inference within the meaning of section 114G of the Evidence Act. While there are such a large number of discrepancies, if a cumulative effect thereto is taken into consideration on the basis whereof the permissive inference would be that the serious doubt are created with respect to prosecution's endeavor to prove the facts of the position of contraband by the appellant. This aspect of the matter has been considered by this court in Jitendra versus State of Madhya Pradesh. Paragraph 6.
So paragraph 9
Not so.
refers to Mohanlal.
Yes, sir.
And some paragraphs of Mohanlal was quoted.
16, 17.
17. Let us read 17.
Of samples at the time of seizure, which more often than not takes place in the absence of magistrate, does not
Does not in the above scheme of things arise.
Yes, Lord. It is correct, Lord.
This is so.
This is so especially when according to section 52A4 of the Act, samples drawn and certified by the magistrate in compliance of subsection 2 and 3 of section 52A above constitute primary evidence for the purpose of trial.
Now,
Suffice to-
next one. Suffice.
Suffice to say that there is no provision in the Act that mandates taking the sample at the time of seizure. That is perhaps why none of the state claim to be taking samples at the time of seizure. Yes, that's why.
So there is no provision in the act.
Yes, it is correct.
So it is this taking of samples at the time of seizure is beyond the provisions of the act.
Yes,
And that was because that was laid down in the notification 89.
yes.
89 para
There are
4. 4,
that is-
4, right?
That is, that is.
I think it is 4.
Actually, in paragraph
Paragraph.
11 of Mohanlal's, it is, they have quoted, Honorable
Hmm?
Supreme Court has quoted this paragraph.
No. 2.1 was not quoted. 2.2.
2.2 has been quoted.
4.0.
2.2 was not quoted.
Yes, no, not quoted.
Now, there it includes drawal of
Simple at the time of seizure.
sample. This part, the court has held that there is no provision in the act,
Yes, sir. It's correct. That is
right? In the scheme of things, it was not there. And where it is held that
Para 4.0.
4.0 drawing of samples before the magistrate in the same notification.
Yes,
And this was discussed in Mohanlal.
Yes,
2.2 also important laws.
Mohanlal in
The paragraph 9 or 10 of Mohanlal's section.
52 start from 15, paragraph number 15. Malat, paragraph number 29 regarding this 89 and paragraph number 29 of
29 of
Mohanlal regarding notification to 16/1/2015 and 1989.
paragraph
29.
29. Twenty-nine of Mohanlal.
Yes,
Mohanlal.
2016. Yes.
1 minute. Mohanlal. Full Mohanlal. Mohanlal. Mohanlal was which citation?
2016. Yes.
16.
181, 2016.
16.
Yes. Page will be.
There was another Mohanlal, 2012.
Yes, there are two.
Thereafter also on Mohanlal 2018. That is repealed also. That is
Paragraph
29.
That is what we indicated in favor of the statute. Is there any report conducting a seizure before the magistrate about the act of seizure?
In this case. Here, notification of 118 was followed. Not interestingly,
89, but 89 also contains that
no, Lordship may come
drawing
to-
of sample.
Lordship may please to come to.
So far, physical quantity, production of physical quantity recovered and seized, that was produced.
That was produced,
Now, question is about drawal of samples.
yes, sir.
And drawal of samples 52A subsection 2 should be before the magistrate
Yes, sir.
and to be certified by the magistrate.
Yes, sir.
And secondly, sending it, the list of samples. Before sending it, it should also be certified.
Inventory. So,
Inventory is to be certified. Secondly, drawal of samples. See, page 52A. Three things. Three things requires compliance. 52A. Three things, ABC.
certifying the correctness of inventory to so prepared, taking the presence of magistrate photograph such drugs, substance or conveyance, and certifying such photographs as true, allowing drawing representative samples of such substance.
Okay, let us see for time being A and B.
Certifying the correctness of inventory so prepared.
Let us leave aside A and B. C.
C. Allowing to draw representative samples of such substance in the presence of such magistrate and certifying the correctness of any list of samples so drawn.
So this certification is mandatory.
Yes, that is mandatory. For section 52.
So another procedure envisaged in standing order 89 of 89 is divorce this provision.
Yes,
Now, after taking of samples at the place of seizure, it was sent, meaning thereby there was no certification from the magistrate.
there was no certification.
So the purpose behind incorporation of this provision is to inject fair play in the provision. So that
Yes.
because a person might be visited with 20 years of imprisonment.
Lordship, my submission before your Lordship, because Lordship has seen that Mohanlal's judgment was passed on 28/1/2016.
That is what I said. That query, now I remember, I put it directly. There is one thing. Statutory provision is in place. Then with somewhat, some deviation, one standing order, which is always for supplementing the statutory provision, not supplanting,
Yes.
right?
Cannot be regulation. to-
Right, which is in deviation,
Yes, yes.
right? You are doing things in accordance with the notification. Everything was complete.
Lordship.
Conviction
Given.
given. Thereafter, Mohanlal came. Wait for
Yes, yes.
Mohanlal came from 2016. Right. Then Mohanlal interprets the provisions
Lordship.
and the standing order. Then any subsequent judgment is to abide by Mohanlal unless Mohanlal has been
Set aside or reverse.
reversed.
Yes. Lordship.
So here the date of seizure was prior to Mohanlal,
Here in.
right? But prior to the date of seizure, 52A was there. By
Yes.
Mohanlal, 52A has been interpreted.
Interpreted and.
Now this appeal is a continuation of the original
Yes.
proceedings.
There is no correlative section what is stated by Lordship. But what I want to.
What is your point
Point
exactly?
is there, because the seizure was made in this case before Mohanlal. Lordship will come to last paragraph of the Mohanlal. Probably it will clarify. Yes, there was a confusion. With
Because the proceeding is still on.
I got Lordship's point, but the point which I'm trying to.
Yes, please, please.
To sum up, we direct as under. One, no sooner, Lordship, please to mark the words. No sooner the seizure of any narcotic and substance control substance and conveyance is effected, the same shall be forwarded to the officer in charge. Then Lordship, nearest police station or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate with an application, so and so, which shall be allowed by the magistrate as soon as may be required under subsection 3 of section 52A, as discharged by us in body of this judgment,
Mhm.
under the heading of seizure and
Which subparagraph you are reading?
last sum up,
31.1.
to sum up,
Hmm.
because this was the direction given by the Supreme Court in the Mohanlal. No sooner the seizure of that,
This is interpreting 52A.
yes, sir. And probably the intention of the Honorable Supreme Court by passing this judgment that 52 should be complied with henceforth. And in Lordship, what has been stated in paragraph 13 and 14, that is also important to be taken note. See paragraph 13 and 14, what has been stated in last paragraph, probably there may be difference of paragraphs. Copy be holding by a Lordship. Probably it may be paragraph 17.
Packet one option, packet one. Packet one option.
See one paragraph of Mohanlal. It's in the recording sum up.
This is a advice or advisory to the department,
Yes.
do in this manner.
Yes. See,
But what has been done? What is the effect? That effect has been explained already, paragraph 8, summarized in paragraph 8,
no, that is correct.
18.
But Lordship, that.
What to do? No.
Just making my submission, Lordship, it is for your.
No,
Lordship
no.
consider-
Tell me, I have, that is why I am asking.
because Lordship, in my humble submission, and that seizure in the present case was done before the Mohanlal case. And in Mohanlal case, Lordship, entire thing has been reconsidered by the Honorable Supreme Court. And Lordship, in one paragraph, it start from suffice to say.
That is why I asked, come up with a judgment. That judgment is not like a rule or statute, unless specifically mentioned a rule or a statutory provision operates prospectively. The same analogy is not applicable in case of a judgment. Judgment interprets
Provision of.
an existing statutory provision
Yes.
or existing rule. Here it says, Mohanlal says, drawing of samples at the place of seizure is abhorrent to the statutory provision and the procedure contained in section 52A. Here the question of prospective or respective operation will not come. That is what, this is my tentative view. And I asked you
Yes, sir.
to come up with some authority with the opposite view. Right.
I prefer Lordship for. But
That is the point exactly I am asking.
Lordship for in my humble submission, to sum up the last paragraph, which is the language of the judgment is very clear. No sooner, that means in future,
You you do this in this manner.
yes. This is mean.
But what would be the consequence of the
Done, already done.
done?
That is, that has not been discussed anywhere. Except.
And my tentative view is that,
Lordship,
so
I-
you either by producing something, you say rebut that view, or otherwise we may have to take that view. That is the exact point I asked you. I
No, no, Lordship. I remember, Lordship.
গন্ডগোল নহয় সেইটো দিছে একেবাৰে বেয়া নাই নাই গন্ডগোল কৰা নাই সেইটো মই কৈ আছো জাজমেণ্টটো perspective কথা জাজমেণ্টে existing provision বা existing rule to interpret it and it will take effect from that violation মানে সেই existing provision to it এই exactly ধুলিয়া চাব এটা ধুনীয়া লিখি দিম মই এইটো কোৱা নাই Uh, 89. Oh. And Jyoti, proceeding was not concluded. Closed cases cannot be opened. Closed cases cannot be opened.
Yes, yes, Lordship. That is.
Right.
That is the law.
Already some cases and conviction has resulted with the procedure of drawing samples at the place of seizure and conviction resulted, appeal closed, then Mohanlal came, those cannot be opened.
That cannot be reopened, Lordship. This is the
Right,
law.
reopen. Now here is a question, it is open in the stage, appellate stage, as well as
Yeah.
at the trial stage.
No,
Judgment was when?
Judgment on Lordship
Is,
16, 2016,
2000?
sorry. Judgment on-
It was prior to 2015.
3/10/2016.
16,
3/10/2016.
When Mohanlal came.
28/1/2016.
So Mohanlal was operating.
Yes, Lordship.
Mohanlal judgment was rendered.
before that, Noor
Mohanlal was referred or not referred?
No, no, not referred.
preferred, that time not preferred,
In the trial court judgment?
No, no, no.
no.
And Lordship, with regard to seizure of sample, no question was put to the IO also. Where seizure was made, whether.
The tutorial provision, tell me.
No, no, Lordship, I'm not on that. No, practical things I'm placing before Lordship. Nothing has been brought on record that any violation is made. There was no complaints of 52A. All these things were not.
That
there.
is why Mr. Kyle, in Mohanlal, we refer to one paragraph.
That is Lordship, I am not disputing that.
That paragraph was paragraph 13, paragraph 12. Seizure and sampling,
Yes.
right? Section 52A.
Hmm.
Then this 2.2 of standing order
Yes, sir.
1989
19.
C
Yes,
was quoted.
yes, sir.
Then all the states and agencies were asked,
Yes.
most of the states,
Yes, they said that they are not correct.
and except
Here,
Directorate of Revenue Intelligence. So your custom stand before the Supreme Court was there. Perhaps we will not go. This is NCB or?
this is custom.
Customs.
See, they claim no samples are drawn at the place of seizure. Directorate of Revenue Intelligence is by far the only agency which claims that the samples are drawn at the time of seizure, while Narcotics Control Bureau asserts that it does not do so. There is thus no uniform practice of procedure being followed by the state or the central agencies in a matter of drawing of samples.
This is
This is therefore an area that needs to be suitably addressed
the light of the.
in the light of the statutory provisions which ought to be strictly observed given the seriousness of the offences under the Act.
We propose to deal with the issue, no matter briefly, in an attempt to remove the confusion that the prevailing regarding the true position as regard the doing.
Drawing of samples. That is the exact point addressed.
The Lordship, in next further paragraph,
15, it is manifest.
it is manifest. This manifest, section 52A2C, Supra, upon seizure of the complaint, the same is to be forwarded either to the officer in charge, the nearest police station, or to the officer empowered under section 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for the purpose, one, certifying the correctness of the inventory, B, certifying the photograph, and C, to draw up representative samples in presence of the magistrate and certifying the correctness of the list of samples so drawn. Subsection 3 of section 52A requires that magistrate shall, as soon as we allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned, any law duty bound to approach the magistrate for the purpose mentioned above, including grant of permission to approach regulatory samples with presence, which samples will then be listed and correctness of list of samples are drawn, certified by the magistrate. In other words, the process of drawing the samples has to be in the presence and under the supervision of magistrate. And the entire exercise has to be verified by him to be correct. The question of drawing samples at the time of seizure, which more often than not take place in the presence of the magistrate, does not in the above scheme of the thing as. This is so specifically when according to section 52A4 of the Act, samples drawn and certified with the magistrate in compliance of subsection 2 and 3 of section 52 above constitutes primary evidence for the purpose of trial. Next line, few lines. Suffice to say that there is no provision in the Act that mandates taking samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. By be as it may, a conflict between the statutory provision governing taking of samples and standing order issued by the central government is evident when the two are placed in just a position. There is no gainsay that such a conflict shall have to be resolved in favor of the statute or first principle of interpretation. But the continuation of statutory notification as it in present form is bound to create confusion in the mind of the authorities concerned instead of helping them in discharging their duties. The central government would therefore do well to re-examine the matter and take suitable steps in the above direction. Then Lordship, we reads the last paragraph where direction was given and the words used by the Honorable Supreme Court. I think that is to be.
Okay. One more. Yusuf,
The latest judgment.
lorry parked, no, latest judgment, but interpreting 52A. A lorry parked near Central Jail, Chennai was intercepted by Narcotics Control Bureau on 28/03/2000. 2000. Mohanlal was not there. 52A was there.
52
Your standing order was there. High Court dismissed the appeal 2022. Then appeal before the Supreme Court. The main plank of his argument is that entire action of seizure and sampling is wholly illegal. It was done in violation of the mandatory provisions of Section 52A(2) of the NDPS Act, as the procedure prescribed therein was not followed in drawing of samples and seizing the alleged narcotic substance. Right? Then to paragraph 10, in order to test the above submission. Paragraph 10 interpreted, 52 quoted, then 12, 52A interpreted, then Mohanlal referred, paragraph 15, and thereafter, once there is no primary evidence, the trial as a whole stands vitiated. That is one.
What is the name of that?
This is Yusuf versus
Yusuf
Yusuf Elias Asif versus State, delivered by Supreme Court on 13/10/2023.
Yes, sir.
This is one. Then you take another one. Simranjit Singh versus State of Punjab. Hence, Mohanlal quoted, that is also much prior, it reached Supreme Court in 2023. I'll just quote one line. Mohanlal quoted, hence the act of PW7 of drawing samples from all the packets at the time of seizure is not in conformity with the law laid down by the court in the case of Mohanlal. This creates a serious doubt about the prosecution's case that substance recovered was a contraband. This is another one.
Arjit.
Simarnjit Singh.
Yes.
Itu আমার আলী সাহাব সিঙ্গেল বেঞ্চ কেন কোয়া নাই আৰু 52A আৰু আছে that another one is Mangilal, right?
Yes, sir.
Mangilal, what was the date of seizure?
Seizure
In case of
2000.
Mangalal Lordship,
2000.
it's after Lordship,
Huh?
after Mohanlal Lordship,
Date of seizure, date of seizure.
Date of seizure is Lordship.
received an information.
2010.
2010.
25.
2010
10.
seizure. Then 52A was there.
Yes.
Standing order was there. Mohanlal was not there.
Mohanlal was there.
Then when it reached Supreme Court, Mohanlal was there. So you cannot say that judgment will operate retrospectively. I have given three instances. Three instances. Now, in the face of these three decisions, after Mohanlal, Mangilal, Simranjit, Yusuf, all the act of seizure and sampling was done prior to Mohanlal. Now, where are the samples? Where is your evidence? Tell me.
That is to be taken to us.
See now from the record.
Yes.
Because the issue is serious, that is why we
No,
are.
no, Lordship.
Dealing with-
Issue is settled. And,
এই মোৰ judgment to use
see, my submission are not adverse to anybody, Lordship.
right?
I'm just assisting your Lordship to.
Being a public prosecutor, you have to be
Not-
fair to everything. More judgment.
Your Lordship judgment is there. Your Lordship judgment is also there on 24.
I have dealt one.
Yes.
I have delivered one. Huh?
So before that, may I submit, may I interrupt, Learned PP Lordship? In Nuraga case, Lordship query regarding this obligatory of the statutory role or not?
Okay.
It is.
Muraga, 1 minute. There are so many, you have bombarded us with so many things.
Yes, it is
Let me find out Nuraga.
2008, 16 SCC Lordship.
We have to locate Nuraga. Prima facie, your submission regarding 42 and 57 would not hold water because of Colonel Singh. This is our tentative view. But so far as 52A is concerned, we are only considering no. What goal hai do?
2008, 16.
Nuraga. Nuraga করছে Nuraga আছিল doesn't found. Yeah, এখানে আছে নাকি?
We have
Dorson?
Lordship.
Dorson Singh was there.
So earlier 40, 40.
Did you
We have,
give it earlier?
I think. Right now, we have 1, 2 more copies.
আছে নাকি? I didn't know how was that. No, কেউ জানে এটা, এরকম থাকলে ছবি লাগিয়ে যাবো। তোমার তো কাছে না, না, এটা তো আমি লক্ষণ নেব। হ্যাঁ? লক্ষণ নেব, ডিকটেশন করি, ডিকটেশন দিই। Nuraga, please,
Yeah,
paragraph
89, 90.
89.
89 and 90. 89 is page number 461.
89.
Yes. Then 90.
This is correct, statutory instructions.
Then-
This standing order was also statutory instructions,
And then-
but it contains two different procedure,
And then.
right? And the authorities, the Supreme Court has summed up in paragraph 30 that henceforth,
Yes.
you please follow the procedure which we have indicated in paragraph so and so, 15 to so and so.
Yes. Yes.
But so far as the proceedings where the seizure and sampling was done in a manner in violation of 52A,
Yes.
then the statutory provision will prevail. The question, see,
That is
no,
mentioned.
this
in
guideline, paragraph,
90, last line.
I have seen it.
Lordship.
I have seen it.
Statutory should.
This, see, this paragraph 89, guidelines
Yes.
issued, right?
Yes.
And these are authorities, subordinate authorities, right? This custom officer, inspector, they are subordinate authorities. And they are served with a notification, standing order. Right? They got confused whether sample is to be drawn as per clause 2.2 at the place of seizure or sample is to be drawn as per 4.0 before the magistrate. So they continue doing drawal of sample,
Yes.
right, at the place of seizure, few or many.
Hmm.
Then that question came up before the Supreme Court. Supreme Court, when asked, you please clarify. Then except Directorate of Revenue Intelligence, everybody is saying, no, we are doing it before the magistrate. This is the position, Mr.
Yes,
Kayal.
yes,
You
yes.
cannot ignore it now.
It is there, Lord. It was there, Lord.
But despite that, cases are surfacing like this one, where samples are drawn at the place of seizure.
Lordship,
Now question next question comes, how Mohanlal is to be applied as sought to be contended by Mr. Kayal. That this act of sampling was done prior to Mohanlal. So directly or indirectly, he is trying to say that Mohanlal will operate prospectively. And that is what the query of the court to Mr. Kayal is, that Mohanlal will not operate prospectively because anything done prior to, subsequent to 52A will be guided by Mohanlal. And I have placed before him 3 instances.
Lordship, you will be surprised to know that even after Mohanlal, till 2020 for notification, confusion was prevailing in different agencies.
Yeah.
Lordship, recently, in 7 cases, acquittal has been given by the trial court on this one.
No, this court on last week on this
Yeah.
ground.
19/7.
So this is the practical situation, because officers there follow guideline, and there was nobody to guide them. This is the-
Because
2020.
no, I know the situation.
And Lordship, if Lordship come to,
Like this, they will only follow departmental guidelines.
yes, that is the difficulty.
They don't follow statutory provisions. সেইটোৱেতো ওপৰৰ কথা শুনিব লাগে, only master, not the super master. Parliament maybe the super master, not here. Oh, boss is going to
There is nobody to guide them. That is another thing. Lordship, may come to page 107
of what?
of the paperwork. Paragraph 15.
15. 107.
107, part of judgment.
Yes. Paragraph.
Paragraph 15. PW 3, Dr. Satyendra Roy is a superintendent of custom. He stated that on 5/12/2014, at about 5 AM, Senior Superintendent DC Pania reported him that 2 trucks were apprehended by custom officers at Bahana Charlie and brought to this office. Accordingly, he went and saw the suspected ganja being unloaded from truck number so and so. He appointed PK Deka as seizing officer and Ramesh Singh as investigating officer of the case, while exhibit 6, which is his signature. Thereafter, suspected ganja was unloaded from truck number so and so. The suspected ganja was then weighted by official weight machine, while exhibit 5 with his signature, and it was found 1093.68 kgs. The suspected ganja were brought by the by consoling under T packets loaded on both trucks. The seizure list and inventory were prepared, and he proved the inventory while exhibit 2-2. The investigating officer collected samples of suspected ganja consisting of 29 packets, which he sent for FSL examination by exhibit 7 with his signature. Exhibit 8 is the receipt of FSL. He also submitted and proved exhibit 9, which is the report as required under section 57 of NDPS. So this was the material.
That exhibit 9 is in purported compliance of section 57,
Yes,
which MS Nargi said are good. Right? Now come to PW2, not PW2. PW3. Second page.
on top. Yes, 6.
First paragraph, second, third, fourth, fifth, sixth. Seizure list
Seizure list
and inventory were prepared in the office.
Please. Exhibit 1,
Then next,
2-1 is my signature.
the investigating officer collected samples from the seized ganja and gave it to me. Magistrate is not required.
was not followed.
I put total 29 of packets of sample in one pocket
Sent to,
and send it to the FSL.
Okay.
So there is no list of samples. Then
no, list of sample is there probably.
where is exhibited?
Yes.
Let us go one by one. This is PW3. Okay. Then you come to PW
I-
PW 5.
Five.
Third page,
Okay.
fourth paragraph.
Thereafter, we draw duplicate samples from each 29 bags of ganja.
Which was supervised by
supervised
Satyendra Rai. He is not a magistrate.
Yes.
Then
but
next,
52 was
next,
not complied with
Next.
statement.
here same. Cross. Okay, skip the cross. PW6. Second page. Fourth paragraph.
All together 29 packets of ganja were recovered and weighment was taken by weighing machines of custom department. Thereafter, the recovered ganja was seized by PK Deka and samples were drawn by him in presence of driver and handyman of the two witnesses.
Then page PW 8
Lots.
IO. Third page. The
Okay.
second, third, fourth, fifth, sixth paragraph.
Samples of each were drawn from each packet. I was present at the time of preparation of inventory. The exhibit 2 is the inventory.
So samples were drawn in absence of the magistrate.
Yes,
There was no certificate. Because certificate, had it been certified by the magistrate, it would have been a primary evidence.
Yes, Lordship,
So
that is there, Lordship.
that part of the primary evidence,
That is not there.
they are not there. So
52A.
the consequent result of the forensic on the basis of those samples, which was not certified, is also to be doubted. That is a law.
No, Lordship, that is correct. But here 52A was not complied with. Notification 1 of 89 and others notifications were correct. And samples were drawn. And Lordship, the sample was drawn from each packets as per prescribed norms and laws. It is correct, Lordship. This is not my submission also. That there is no materials available in the record that at the time of drawing sample, magistrate was present. But Lordship, exhibit 2 was placed before the landed magistrate also.
Which one?
Lordship, and please.
Exhibit 2. Let us see. What is exhibit 2?
23.
123.
List of samples.
Inventory of goods seized. Lordship on top. Seen Chief Judicial Magistrate Kamrup on 6/12/2014.
Seen and certified. This is 120?
No, Lordship, this is not my submission that 52A was complied with. Subsequently, it was produced before the magistrate on 6/12/2022.
612. One thing is clear that, to accept that also it is difficult because then you have to produce all this Malkhana register and all. But consignment that was in physical form was presented, I think. The entire quantity was presented before the trial court.
That Lordship, I have to check.
Yes, I have seen it.
Yes, it is in seizing officer, PW5.
PW5. He presented
Presented.
somewhere. I have brought the seized articles with duplicate samples.
Yes.
But the foundation required to produce those duplicate samples, that was not laid down. And Met Exhibit 1 to 29 are seized packet of cannabis ganja
Hmm.
in sealed condition.
Metal.
Met Exhibit 30, paper carton in sealed condition of 29 packets of samples of ganja. Each sample of 30 gram were drawn from each packet for 2 sets of sample. This part is required to be certified. This drawal of sample in duplicate,
Yes, Lordship, that as per section 52A, before magistrate, all these things has to be done.
this is to be done when a statute requests a particular thing to be done in a particular manner, that it must be done in that manner, in no other manner. 36 Privy Council.
Here, Lordship may come to page 129, the report of FSA. Description.
That we admit.
It is also tele with the samples drawn.
Drawn.
Yes, Lordship, I'm hit on that.
There is one gap.
Yes, Lordship, that is there.
That gap is big enough.
For that, my explanation I have already placed before.
Will record the
And,
submission.
Lordship may verify.
We have to rise also.
Lordship.
Uh,
May resume on next week.
Next week, Friday, only, but audience will be only 5 minutes,
Yes,
5
sir.
minutes. We'll start dictating the judgment.
Yes,
I have placed one judgment of latest appeals for judgment lordship, Mohammed Khalid, 2024. Right?
Khalid,
Yes. Here,
1 minute. Let me find out. Khalid. Asa nahi Khalid. Yusuf to ase.
Khalid disposed of June,
When?
March. It is,
Khalid.
yes. But Khalid, just now I have placed my,
Just now.
yes. I have highlighted lordship kindly. Sir.
Oh.
Here is it. Whatever,
You have given 1 copy or what?
2 copies.
What ase to?
Last paragraph 26 page.
26.
Yes. Last page, Lord.
This is
Last
by
page.
Justice Goy and Sandeep Mehta also. 1st of March 2024.
Yes.
Oh.
Judgment primarily deals with confessional statement. recorded
Very
by-
categorical.
Yes,
FSL report is nothing but a
piece of paper.
West.
waste paper.
Yes, sir, that is been.
Cannot be read in evidence.
I've gone through that.
What more?
But Lordship,
Khalid to acquire a citation.
Lordship after
Ah.
Wednesday, because Monday, Tuesday, Wednesday, I will be in Hyderabad. Yes, maybe fixed after
Next week,
Wednesday.
next.
Next week only. We are aware about our roster position only till next week.
Next week.
এটা কই দিব লাগিব, who cover, দুটা কথা দি দিম। But audience is only 5 minutes,
Yes, sir.
not more.
And Lordship, one judgment that is not related to NDPS or criminal, civil. Supreme Court very beautifully mentioned about the precedent and that such. I'll place judgment and for consideration of Lordship. Otherwise, Lordship, facts is clear.
Exactly. Heard. I go to repeat heard Miss S.K. Nargis, learned counsel for the appellant, and Mr. S.C. Kyle, learned public prosecutor, customs for the respondents. So Mr. Kyle has submitted that as his submissions is not complete. The appeals will be listed again in the next week. First of, as sought for by Mr. Kyle, public prosecutor customs is the appeals in the next week on a date to be fixed by the office as part of. I think that, no?